So John and I, this is our favorite time to engage with our clients. So we're looking forward to having you here today. So we're going to have a dog and pony show, as John normally puts it. Can I please request that everyone mutes themselves to make sure that we all can hear each other? So this is a session that is very important. So we'd like to make sure that we are not interrupted by people not having their mute buttons. So just to take you through the learning outcomes for today, before I do that, I just want to touch on the house rules, that we do appreciate your comments, your questions. This is an interactive session, although we might not be answering always, but it's great that if you can put your questions, John and I will be answering as we go. Some of them we should be able to answer you and read them out and answer to you. So we are recording the session, so you will get the recording as well as the slides after the session is completed. So John, thank you very much. Let me continue with the next set of slides, please. So what we're going to cover is the current amendments and also the ABCs of employment equity compliance. And we realize that, you know, with these changes and amendments that are taking place, we are going to be required to have, you know, our ABCs in check, because not only could you receive a certificate of non-compliance, you can also receive a fine for non-compliance. So that's very, very important that we also take you through the ABCs of compliance, as well as the sectoral targets. We'll talk to that, and the planning tool, which is just made for you, which we're very proud to share with you as our clients. And then also just the justifiable grounds for not meeting the targets. And also, how does this certificate of compliance link to the triple PFA and the triple BEE? So that's quite important for us to share with you. Again, do you know? Sorry. Okay, we will explain that to you soon. Triple PFA is Preferential Procurement Policy Frameworks Act. You can put that on the chat box next time. And the broad-based Black economic empowerment, those are the acronyms which we're going to unpack as we go. And so it's important, obviously, that we would, our aim is for you to gain the insight so that we can have all the necessary requirements that you need. I keep on muting this person, John. I'm not sure. And yeah, okay. And they're unmuting themselves. Okay, thank you so much, John, for this. So we thought, as our clients, and you've signed up, we will give you an insight to what the Department of Employment and Labour is planning. We do know that the schedule will be posted soon on the website. Those are just the dates that they're looking at for running the workshops, the roadshow workshops, as they usually do. So we thought, if you are in these areas and you want to already put this in your diary, it is very important that you go and hear exactly from the Department of Employment and Labour what they are planning to do with the sectoral targets and what are the new changes, if there are any. So we know that currently they are sitting and amending the system to be aligned to the sectoral targets, that should the president sign, it will be imminent that we should be reporting in that format. So as it stands, the president has not yet signed. You can come to the next slide, John. The president has not yet signed, and we aren't really sure at this stage when he's going to sign, but it can be any time from now. He has been busy signing new bills, and he has signed a legislation on the the harassment, sexual assaults and abuse, as we know that we are now, we have entered the Women's Month. And obviously there's a lot of sexual assault that is taking place, and he's signed a new bill on that. So he's signed about 3 bills, I believe, in the last week. So I think this one is also on his desk, and he should be looking at it soon. We are hoping that we should be able to see that. So John, don't know if you want to go through this slide. I think there's something going on with the slide. It's not showing my side. Okay, thank you, John. Right. So we're going to take you through the ABCs. So the next slide is really going to tell you about, the importance or rather the requirements that are important in the employment equity implementation. So I thought I'll take you through some of these. So the first one is the EE manager, or the assigned senior manager, which is an important requirement, Section 24 of the Act, which says that all the employers must assign 1 or more senior managers to coordinate and ensure that the employment equity legislation is properly implemented in the workplace. And this person is supported by the Employment Equity Committee that is nominated. And I'll tell you about the changes on that consultation process. And this person must report directly to the CEO. They must be given responsibilities and resources to ensure, and the budget to run employment equity matters. And important out of this point is that this person must be an employee of the company for that particular appointment. However, employers are allowed to employ consultants to assist the EE managers of their companies, but they need to make sure that the person who's provided the letter of appointment is an employee of the company. And this is the person that must also run with the meetings, and they must be present at meetings, because it can be an audit finding that the employment equity manager of your company is not present when it comes to employment equity meetings and implementation of employment equity. So this is one of the findings that the IES, the Inspectorate Department, has picked up when doing the audits with various companies. They've picked up that employers have got employment equity managers in terms of their reporting, but when they were requested to provide letters, they did not have relevant appointment letters that are needed. And when they had gone through the minutes of the meetings, these people that are appointed are never even attending these meetings. So that is a finding that in terms of Schedule 1, which is the fines, a company can be fined 1.5 million rands for not having that correct. So that's why we thought we'll give you the ABCs to understand the importance of this. We also need to create awareness. So all employees, according to Section 60 of the Employment Equity Act, it is the employer's obligation to ensure that all employees are aware of their rights to fairness, rights not to be unfairly discriminated, and also if there's any form of harassment, that those employers would be liable for that conduct of the employees. So that's why it is vital that even the employees that are not part of the EE committee, that they understand their rights as well as their responsibilities. Because when it comes to harassment, even the employees can make the employer liable for harassment cases if they don't understand, that is, if they discriminate unfairly against other employees. So that's quite important. So we also just need to, so John, something is happening with your slide here. Keeps on, I can just get that view. Thanks. I can see you. Actually have the wrong glasses. I have the shades instead of the right glasses. So, because I can't see. Thank you. So thanks, John, for this. There was just an issue. So nominating and electing of the EE committee members, very important. They must be trained, understand their roles and responsibilities, and ensure that they also participate meaningfully in the employment equity activities. We find that most companies, their employees are not understanding their role properly, and we find that it becomes an HR show as opposed to employees giving their input in the employment equity matters. So we do suggest that companies perhaps set up and organize their committees in subcommittees where you can actually allocate certain individuals, maybe 3 or 4 individuals, to deal with certain aspects of the employment equity. It can be people that monitor your recruitment processes, your promotions, your succession planning, and the other subcommittees can deal with issues of diversity and inclusion in the workplace, and also awareness on disabilities. So that is what we hoping that you can take out of this is, the practical ways of how your committees can be actively involved and also take the burden away from the HR colleagues. So they're there to help you to identify those barriers. They can do that through various ways where you could do the surveys. You can also do the the short meetings, or where we have the task teams, or employees sit in small groups and discuss with their colleagues on what they believe are the barriers. And they would then help you to identify corrective measures that will promote a diverse and inclusive work environment. And that informs your EE plan. So we can see that in our employment equity planning, it is important that employers must have measures in place that will promote a diverse and an inclusive working environment. So it's not only enough that you're recruiting, but you also need to put measures on how we can eliminate barriers to appointments and recruitment, subconscious biases that, people that are in recruitment can have, which they might not even be aware of. So that's quite important. So those are all what we call the affirmative action measures that need to be in place. We'd also draft the plan and monitor that. Thanks, John. So those are your ABCs of implementing employment equity. And really critical to this is that as an employer, you have duties to comply with. And these are the duties for the designated employer, which then in turn become the responsibilities of the committee. Because for all these sections that we're referring to here to be properly implemented, we need a company to have a proper nomination process where employees from different backgrounds, including your trade union or shop steward or your majority trade union now in terms of the new amendment on Section 16, that those would be the ones that are consulted. However, that consultation must also reflect the interest of all occupational levels, so people from top management all the way down to your unskilled level, whilst your unskilled level may be represented by your shop steward. So, but the other occupational levels must be equitably represented as well. People from designated groups and those who are not from the designated groups, as well as your senior manager that is assigned in the form of EE manager. So that's your consultative process that needs to be in place. And this can be done in various ways, because we know most companies, they have challenges in getting people nominated. Sometimes we find employees not interested in participating in employment equity. Maybe they've seen that in the past, nothing has really been done. So they are reluctant to become part of employment equity processes. So companies are legally bound to have an employment equity consultation process. So what does that do then to the company's compliance? So that's why we then suggest to companies that if you can demonstrate that you've gone through the process of nomination and that has failed, you can go through the process of co-opting individuals in line with the requirements of what Section 16 needs. And once you've co-opted those individuals, you can then offer them letters of acceptance, and then they can receive training in terms of their roles and responsibilities and sign terms of reference in terms of what they would be doing in the committee. So the co-opting process is allowed, but it is important from an audit point of view to document that process and ensure that we've got it sorted. So the role of that committee is to then help the organization to identify the barriers from policies and procedures. So going forward, we are required that we definitely review our policies and procedures to see if there are any barriers that could be preventing companies from achieving, especially with the sectoral targets coming up. And then, of course, we need to deal with the issues of equal pay for work of equal value. So we have the income differentials that also need to be audited, because if there are employees that are claiming unfair discrimination on the basis of equal pay, that can be seen as a barrier. So organizations need to do proper analysis of their remuneration processes, have a remuneration policy, and identify where you have gaps and have measures that you can implement to correct those measures. So that's part of the analysis. So based on the analysis, you are required to have objectives as well as your employment equity targets. And these targets and objectives must be documented in the EEA 13 form, which is most likely going to be amended going forward to include the sectoral targets is amended in the legislation, in the Employment Equity Bill. So that template will change. And of course, when it changes, it will be put on regulation that you will see what template that you are using. And also your template will then have your yearly targets, which we're going to refer to just now. And then your objectives must also be clear. What are your objectives that you want to achieve as part of your EE plan? And again, the Department of Labor has been quite busy in the audits that they've done to say to companies, they need to review their objectives, because most of the objectives companies have reported, according to the Department of Labor, they haven't been using the SMART process, which is specific, measurable, attainable, realistic, and time-bound objectives. So what this means is, if we are doing an assessment and analysis and we're identifying barriers, the affirmative action measures that we identify must be tested against the SMART process. So that you can use that as your objective. If we've identified that you have people with disabilities, or you have an underrepresentation of people with disabilities, your measures might be to create an awareness with all the employees in place. It may also be that you want to recruit more people, and you can have then the percentage of what you want to recruit. So that's a specific measure, and that then can be your objectives. So the targets will be over a 5-year period, and we'll take you through that as part of the changes that we're having. And then, of course, your reports to evaluate how well have you performed on your plan for that year. Thanks, John. So we can skip this page, John, because I think it really talks to the detail of what I've explained on the ABCs of the employment equity. But maybe just a quick one on this one. I just want to touch on the EA1 form. So the EA1 form is also just one of the important forms that we will need to update as organizations, because that informs your EE plan, and organizations would then need to ensure that this is properly documented as well in your organization. And I've touched on all of these. Thanks, John. I think we can move on. Let's see, are there any questions in the meantime? Let's see. All right, so Maria says, our EE manager is a company director because the staff do not have a say. Is that okay? Absolutely. It must be a person with authority, Maria. So that's actually a good thing that you have somebody with authority to make a decision. So the role of the EE manager is very important. It's a strategic role in the sense that they are the ones who can assist the CEO when it comes to deviations and also ensuring that employment equity is implemented. In fact, that's the person that gets the call from the Department of Labor or gets the email when they have an audit. It's between the EE manager and the CEO. So especially going forwards when companies need to ensure that they comply with the sectoral targets, if there are deviations in appointments and development that can enhance your sectoral targets, that person needs to have the authority to call out the individuals that may be going against what the requirements are, because the implications of non-compliance are huge. So yes, absolutely, that is okay. Thanks, John. You can probably take over from here.
Thank you, Thembi. Good morning, everybody. Good to have you with us. I must say I am a Zoom favorite, not so much Teams. So please forgive me if I struggle a bit with these particular slides and to try and see what's going on. But it's really great to have you here. So Thembi, maybe just one or two comments. I think based on what you said, we've got to really understand the importance of income differentials and equal pay for work of equal value. We see the Companies Act also that is being amended, and organizations are going to have to make much more disclosure in terms of the earnings, both vertically and horizontally, and income differentials and what organizations are doing in that regard. The other thing I want to just mention before we look at the current status of the bill, Thames, and I mean, you and I were talking about it before the start of today's session, but remember, colleagues, culture eats strategy for breakfast, right? So what's critically important going forward is we need to hold the mirror up in our organizations and say, do we have the enabling culture in our organizations to ensure that we achieve the objectives of what lies ahead? The challenge that we find, colleagues, is we don't have a safe place in organizations. Employment equity is not given the necessary enabling culture and DNA in terms of leading and managing with emotional intelligence. And the nature and extent of what is required here means that our line managers have to be empowered to have courageous conversations, to make the right decisions, and to make them in an environment that is underpinned by a psychological sense of safety. But nevertheless, more about that later on. Now, colleagues, where do we stand in terms of the promulgation of the bill? We see this, and I'd highly encourage you to go and take a look at the Parliamentary Monitoring Group. If you just Google Parliamentary Monitoring Group, you'll see all the laws, all the bills that are before Parliament. And this is an example of how they demonstrate and articulate where we're at. So the Employment Equity Amendment Bill, as you can see, has been approved by the National Council of Provinces. We are waiting for the President to sign this off. And in terms of that, you know, we are now waiting. Of course, in parallel with this is the ongoing process of consultation by the Department of Employment and Labour with the various sectors to try and tie down the ministerial sectoral targets. But Thembi, maybe to get more detailed insight from you, I think the question on everyone's minds right now is, when can we expect President Ramaphosa to now take the final step and to sign the amendment bill into law?
Thanks, John. I wish I could give you the exact answer for this, but it's a very difficult one, given the fact that our president is quite busy at this stage with the various things that are in his plate. But as I've indicated to you earlier before I chat, you know, in the commission that I sit on, we've had some sort of deliberation as to when possibly the president would be signing. I think everyone is kind of aware of his situation at the moment. So it's possibly that it will still be this year sometime, hopefully before the end of September. But it doesn't give us enough time, John, to really go through everything that needs to happen. As you know, that there are sectoral targets that are taking place, or engagements with the different sectors. Some are at the final stages. I know that the mining sector has reached consensus. The administration sector as well, from Cape's point of view, have also accepted the proposal from the department. There are various other sectors that have been engaged that have reached consensus. So safe to say that the commission and the department are getting closer to finalizing the sectoral engagements, which hopefully by the end of this month, they will be able to send or publish those as Gazette for public comments, where you have an opportunity to have a stab on your sector target. If you've got any reservations, you are allowed to do so, and that process will be finalized. And depending on when that is finalized, then the whole submission and the EE plans will kick in. So really, realistically, if one looks at that process, it is most likely that the employment equity submission or new plans will kick in probably even next year. But as it stands, we still have the October date as what the department had said, but internally, what I can inform you is that there is a sense that it will probably kickstart from February 2023.
So colleagues, based on what Thembi's shared with us, it looks like even if the Employment Equity Amendment Bill is signed by the President into law, the reporting period, Thembi, for this year would still be based on the existing plans, because the ministerial targets, the sectoral targets, would only then come in probably early next year. What it does mean, colleagues, is that you've got a little bit of time to ensure that all the things Thembi's taken you through, that whole flow diagram, re-establishing your committees, making sure you've got a solid foundation, your senior manager responsible for employment equity, get that in place, colleagues. Run the numbers, do the analytics around income differentials, revisit your policies, your procedures, your whole employment life cycle, because once those targets are in place, we will see now exactly what the pressure points are if you miss out on that. But in order to get into the mind and the heart of the Department of Employment and Labour, it's critical to take a look at what happened during the parliamentary process, because this answers a number of questions that might be in the back of your mind. So let's take a look at what were the key issues that other stakeholders, in terms of business, in terms of other labour forums, in terms of civil society, what were the challenges that were presented in terms of these proposed amendments? So we're going to take a look at 5 areas that were on the radar during this process, because they'll give you insight into what is going to happen. So the constitutionality, colleagues, in respect of the targets, the ministerial targets, were put on the radar. You know, the question is saying, aren't these quotas, and aren't quotas specifically outlawed in terms of the Act? The second area we're going to look at is consultation, and Thembi's touched on this. You're going to be very, very interested to see that there are very specific changes to consultation requirements based on the amendments. And how do we respond to that? The third one is the issue, again, of who you consult with. Thames, can you hear me?
I can hear you, John.
Great, thank you. So the next one is Section 53 of the Employment Equity Act. And of course, Section 53 is a major challenge that organizations need to be aware of, because that talks to the conditions under which a certificate of compliance will be issued to organizations. And colleagues, very importantly, not only the certificate of compliance for compliance with employment equity, but we're going to be touching on what is the impact going to be on BBBEE verifications in terms of management control, and then also the Preferential Procurement Policy Framework Act. So, colleagues, these are areas that were put on the table during these discussions. And then the final one is penalties. Now, we do know, colleagues, that there are percentages of turnover, or 1.5 million rand, as Thembi said, if organizations and designated employers do not comply with various sections. But I want to make it very clear today, these fines and penalties are not just for breaching the provisions of having a proper consultative forum. These fines and penalties are not just there for not having a proper plan or submitting your reports. I want to make it clear that you could potentially also be fined for not making reasonable progress in achieving your targets. And this was one of the issues that was put on the table, saying, isn't this double jeopardy? Because if you don't meet your sectoral targets, not only will you not get a certificate of compliance, but you might also be facing a fine. So let's take a look very briefly, colleagues, at these challenges and how the Department of Employment and Labour answered these submissions. Well, the first one is the Department of Employment and Labour on the issue of quotas versus targets. The Department of Employment and Labour said, listen, Section 15 of the Act says that affirmative action measures must be aimed at getting equitable representation at all occupational levels, and this hasn't happened. So the Department of Employment and Labour are saying the anchor is we still do not have equitable representation. The second thing is the Department of Employment and Labour referred to Section 15, and this is what I spoke about earlier, colleagues, where it says in paragraph B, it doesn't suggest it, it says designated employers must take steps to further diversity in the workplace. Now, furthering of diversity talks about entrenching a climate and a culture of diversity, equity, inclusion, and belonging. And this is probably the biggest reason why organizations have failed to achieve their particular transformational targets over the past 20 years. You see, colleagues, the secret of our future is hidden in our daily routine. When it comes to employment equity, our daily routine is how we recruit, how we select, how we promote, and how we retain people. And off the back of that, we've got to really ask ourselves, do we have the right culture that drives this behavior? Because our culture and our values drives how we conduct ourselves. The Department of Employment and Labour then go to the fact in Section 15, subsection 3, they say, we do know Section 15 of the Employment Equity Act says employment equity includes preferential treatment and numerical goals, but excludes quotas. And the Department of Employment and Labour say, of course, we're complying with the Act because there's a difference, colleagues, between quotas and targets. And this slide is the exact slide that the Department of Employment and Labour put up on the screen. And they said, listen, quotas are mandatory outcomes. In other words, they are rigid and they must be achieved at all costs. And they said that their amendments and the fact that the minister has got sectoral targets are not quotas because targets are aspirational goals. So in other words, they're saying the 5-year targets that Thembi and I are going to take you through per sector are aspirational. They are flexible because organizations need to take steps to achieve the goals where reasonably practicable. So they're acknowledging that there might be circumstances where organizations do not meet those targets, but where there are still justifiable reasons. And colleagues, this is critically important. It's very, very important, because they're saying these are not quotas, they are targets, because you may still not achieve your targets, but then you will have to present justifiable reasons. Now, on the right-hand side, you will see the employment equity regulations that talk to the issue of the EEA 15 form. In other words, colleagues, if you do not achieve your annual targets building up to the 5th year, the ministerial targets, there are only 7 reasons that you can rely on to justify not achieving your targets. And I always joke, I say, you know, we read, well, I don't read, but there are 50 shades of gray and there are 100 ways to leave your lovers. But, you know, when it comes to employment equity and not meeting your targets, there are only 7 justifiable reasons. And these 7 reasons are set out: insufficient recruitment opportunities, insufficient promotion opportunities, insufficient skills, court orders, transfers, mergers and acquisitions. And then the final one is business or economic circumstances, just like, for example, COVID-19 or socio-economic disruptors or political unrest. You see, colleagues, the point is, this is why they are not quotas, because you do have flexibility, but you're going to have to justify it. You're going to have to lead evidence that if you don't achieve your targets, that one of these 7 reasons apply. And of course, this is the response. So when Business Unity South Africa, they made a submission and they said, listen, what is the point of consultation under Section 16? Why even consult if the minister is actually setting the targets? And the Department of Employment and Labour said, listen, that's not true, because the minister is setting targets for the 5th year in terms of a 5-year plan. But as you can see here, organizations still set their own annual targets. So for 2023, 2024, 2025, 2026, 2027, you're still going to consult in your forums and your committees. You're still going to look at your business environment. You're going to set your annual targets. And of course, you're going to decide the strategies and the plans to underpin the achievement. So in other words, the need to consult is not being rubbished. In fact, consultation is still as applicable as before. Now comes the question to the Department of Employment and Labour, because if you look at the proposed amendments, colleagues, you'll see where my cursor is. In Section 16, it says that you must consult with a representative trade union representing members at the workplace. They've removed and its employees or representatives nominated by them. So the first port of call, colleagues, is that under the amendments, your consultative forum, if you have got a representative trade union, talks to a majority trade union. Now, this is where, Thembi, and we need your input on this, but this is where, colleagues, if you have a majority trade union, in other words, the definition here of representative is majority. If you've got a majority trade union, well, then you must consult with that trade union.
So we've got to have a member of the trade union on the employment equity.
Oh, does that deficient? Because I've tried for more.
Sorry, colleagues, if you could mute yourself. I'm not sure where the feedback's coming through. But you can see now then in subsection 16(1)(b), it said if there's no representative trade union, in other words, there's no majority trade union, then you must, talk and consult with the members of the workplace. In other words, the employees or their representatives. Now, the challenge here, colleagues, is that if you have a representative majority trade union, that trade union, Thembi, might not meet the needs of Section 16, subsection 2. In other words, if you've got a majority union, how do you ensure that you still have all occupational levels represented? In other words, top, senior, middle, and junior management. How do you ensure that you've got African, Indian, colored, white, people with disabilities, etc., and people who are not from designated groups? Tembian, and this is, I think, an advisory requirement to clients now, because if you've got a majority union, but you're not representing all levels, designated and non-designated groups, what do you do? You know, do you have a separate parallel process, Thames? What is your view in this regard?
Thanks, John. So my first view is that the employer and the trade union responsible need to be in consultation on the process, whilst the employer on this particular subsection is not responsible for ensuring that the trade union, how the trade union does this, but it is a requirement still that the employer must ensure that it happens, because ultimately the employer has the obligation on Section 16, as it is a duty of the employer to ensure that they're compliant. So I would suggest that in deciding that that majority trade union is going to look at the consultative forum, that they can discuss with either the management on who are the people that will be nominated and represent the, within that trade union as a consultative forum. But I think the practical really way is, if the trade union does not agree that management must be involved in the process of nomination, and the company should then run a parallel process, because ultimately the liability still lies with that company or that employer to ensure that they've complied. It's not necessarily going to be the trade union that gets the fines if they found not compliant on Section 16. So I think that's the way that this would work. But what it does, though, John, is it's reducing the confusion or the usual fights that you get in organizations where you have a lot of shop stewards represented in a committee, or wanting to be represented in the committee, because they come from different unions and they want to sort of show themselves off to their members. So what this is doing, it's deciding that that majority or sufficiently represented trade union will be the one that the employer is obliged to consult with. So that's really the main issue I think they were trying to address with this, which comes up with its own challenges on its own, because by rectifying one thing, you are messing up the other, which is still a requirement in terms of the Act.
Yeah, Tembi, thanks. And I see you've been feverishly answering questions behind the scenes, and thank you for that. So colleagues, less than 50 people, 50 or less, you wouldn't be a designated employer in terms of Chapter 3. But as Tembi indicated, you'll deregister only after the Act has been signed into, the Amendment Act has been approved by the President. Tembi, Ryan says, if you have a recognized union, but they're not a majority, should you consult with them? And I mean, the reality is, if it's not a majority, then Section 16(2) would kick in, because then obviously you've got to have trade union and non-trade union representation. Thames, is that right?
Yeah, that is correct, John. And also, I think Corne has also answered, the fact that LRA talks about sufficient representation. So yes, if that trade union is sufficiently represented, you can still consult with them.
Yeah, so Corne, I mean, under the amendments in the Employment Equity Act, although they're talking about sufficient representation, they talk about a representative trade union. There, they're actually talking about a majority. So representative trade union under the Employment Equity Act, Section 16, specifically refers to a majority union. We know that in the LRA, they talk about sufficient representation, could be 25% plus, for example. But the bottom line, Corné, is you have to include trade union members in your consultative forum. You know, in terms of even if they're just sufficient, not majority, they would still have to be included in that particular forum. So, colleagues, if we move forward, you know, these are indicative of some of the sentiments of the Department of Employment and Labour. Now, what was interesting is if you look at Section 53, a number of business organizations asked the Department of Employment and Labour to include the clause or has taken reasonable steps to comply with these targets. In other words, Section 53 talks about issuing a certificate of compliance, and the minister must be satisfied that the employer has complied with the numerical targets that were set in terms of Section 15 capital A. In other words, the minister should only issue a certificate of compliance if the company has complied with the minister's targets, and then the business wanted them to add in or has taken reasonable steps to comply. And to put that in the actual main body of the Employment Equity Act, and the Department of Employment and Labour said, no way. We are going to keep it, and I'm just going back, we're going to keep the justifiable reasonable grounds in the regulations as per this slide here, but we are not going to put it into the main body of the Employment Equity Act, and we're not going to talk about reasonable steps. We are going to talk about justifiable reasonable steps, because they said if we include it in the main body of the Employment Equity Act, it's going to open up a floodgates of companies making allegations and submissions that, you know, they took reasonable steps but couldn't comply. You know, there weren't enough skills, there weren't this, there weren't that, and the other. So Department of Employment and Labour said we'll cover that in the regulations under the heading of justifiable reasonable steps. So colleagues, the bottom line is, if you're going to be relying on any grounds for not meeting your targets, you would have to lead evidence that you didn't have recruitment, promotion, retention, and skills development opportunities. Now, some of the questions, Thembi, were asked about the system. So colleagues, let me cover this, and Thembi, please feel free to add. But the bottom line is your Employment Equity Certificate of Compliance will be done by declaration. In other words, you'd submit your EEA 15 form and through automation through the employment equity system. So in other words, your online submissions will result in an automatic process of adjudication. Once you submit your EEA 2 and your EEA 4, especially your EEA 2, what will happen behind the scenes, colleagues, is there will be an assessment of whether or not you've met your targets. Your 2023, 24, etc. The system will then have intelligence built into it, and immediately they'll say, have you as an organization met or have you not met your targets? In addition to that, there'll be an interface with the CCMA case management system, as well as the National Minimum Wage Exemption System and Labour Court registers. So in other words, there'll be an assessment of, did you meet your targets? Secondly, there will be an interface to say, are there any CCMA or Labour Court findings against you as an organization in the context of breaches of employment equity? In other words, unfair discrimination. And the third check, colleagues, is going to be, have you been exempted from paying national minimum wages under the National Minimum Wage Commission? Obviously, if the answers to any of those three is no, you haven't achieved your targets, you've been found wanting in terms of an unfair discrimination case, an award against you, or a Labour Court decision against you, or if you're paying less than minimum wages and you have not been given any exemption from national minimum wages, you will not get your certificate of compliance. What is the repercussion of that? Well, colleagues, the bottom line is you will not be able to tender for government contracts. You will not be able to probably eventually be verified in terms of management control under the BE verification procedures for management control. And chances are, colleagues, that you will also, in many instances, be excluded even from private sector tenders, because many companies, although they won't have to do it, will probably ask you for your tender submissions to include your certificate of compliance, even in the private sector. But Thembi, maybe it's opportune for you to share with us as colleagues and on this call as well, what is happening right now in terms of, we understand no certificate of compliance means exclusion from public sector tenders. How will it impact BEE verification, Thembi, in your view going forward?
Thanks, John. So if you look at the BEE pillars, so there's 5 of them, which is ownership, management, control, which includes the employment equity targets. You are required under the management control to currently provide proof that you have submitted to the Department of Employment and Labour, that you've complied with employment equity requirements in as far as the reports and the plans are concerned. So that's quite an easy process as it stands. And employers that are small, say qualifying small enterprises, which are not Black owned, they are required to also provide, you know, this proof for the purposes of BEE verification. So going forwards, the discussions between the Employment Commission, Employment Equity Commission and the BEE Commission is that there's got to be an alignment to these processes, that for management control, which is currently not a priority area under the BEE scorecard verification, should also seek the proof of compliance. That is the certificate of employment equity compliance, which will now have an impact on whether or not you receive your points that should be allocated if you are being verified under the management control. So there's obviously a huge implication for those companies now, because if you're not compliant on employment equity, you then forfeit your management control pillar, which is an entire pillar which is inclusive of your board representation, your management, and your persons with disabilities. And those are the indicators that are verified under the BEE scorecard pillar. So that's the implication that you have. And of course, a question was asked here about what happens to smaller companies. Would they now be required to submit the employment equity reports and plans? You under 50 employees, you're not required to submit plans or reports or have an employment equity committee, any of that. But you have to comply with Chapter 2, which is about elimination of unfair discrimination. That if you are referred to the CCMA or Labour Court and the employee has won that case against your company, and there is an award that is issued against your company. So as a small company, you would not receive a certificate of compliance. So if you are one of those employers that now need a BEE certificate because you have a tender with the government, that will have an impact, a negative impact to your company. Even though from an EE point of view, we're not required to comply in terms of submissions and all of that. The fact that you have been found liable on an unfair discrimination case, they will not issue a certificate of compliance on those grounds. So that's how this is going to impact companies, from generally all companies as well as the small businesses under the BEE certificate. So I think that's where the major impact will be felt by all companies.
So Thembi, thanks for that. So colleagues, there's another question here. So let me just confirm the following. There are bilateral discussions between the Employment Equity Commission and the BEE Commission. Those discussions are likely to result in a qualifying criteria for BEE under management control, that if you do not have a certificate of compliance as per the EA 16, then chances are you will not be verified under management control, and those 19 points or whatever it is in your sector charter will be forfeited. It's not yet agreed, Thames. It's currently being discussed bilaterally, but it would certainly be evident that that is going to be the outcome, just like for skills development. You know, you've got to give proof of the WSP ATR submission and the acceptance of that plan, Thames.
100%, John.
So colleagues, Thembi and I, we can talk a hind leg off a donkey, right? So maybe let's just summarize the big ticket items thus far. I think the first thing, Thames, and help me here in summary, the first thing, colleagues, is we said to you, build a firm foundation for the future. That flow diagram Thembi showed you up front. Get your committee sorted, make sure it's representative. If you've got a majority union, we've pointed out that union is it, but you still then have to make sure you cover all levels and designated and non-designated groups. The third thing we wanted to point out, colleagues, is that these are not quotas, they are still targets. Consultation is still incredibly necessary, because even though the 5th year, the minister's targets for the 5th year are set, you still got to look at your business and you got to say what targets are justifiable and reasonable in year 1, 2, 3, and 4 en route to year 5. That requires consultation, it requires planning, it requires a review of our policies, our procedures, etc. The last thing we're touching on now is we're saying to you, the crux of the matter is you need a certificate of compliance for various reasons. Even if you don't transact with government, and you might say, well, what's the point? We're saying to you, it could flow through to your BE verifications, and even the private sector's personal private procurement procedures. If you go into Nampak, or if you go into Standard Bank, or if you go into other companies, they might very well also build in a certificate of compliance. So colleagues, really, really important to get this right. What are we saying to you? Well, if in 20 years organizations have not transformed sufficiently, you need to do something different. We need to do something different, colleagues, and that has to be vested in the culture of the organization. But let's move forward and let's talk about, Thembi, the key amendments to the Act. Let's get into the details here. I know you were struggling with your glasses just now, Thames, when I put a very small version of our slides on the screen. Tell me, are you disabled, Thames? Do you have a sensory impairment?
John, I must say, I feel that I am beginning to become disabled, because even without my glasses now, I am struggling a little bit, but not so much. I must add, I think my disability here is more of the age issue rather than me not wearing my glasses. So my glasses are really helping me to be able to see the screen bigger, but without them, anywhere else I can see, but it's where I am faced with the small print like you subjected me to, John. So some of these changes are obviously trying to assist employers to draft policies in place to make sure that we have a reasonable accommodation for persons with disabilities who are often discriminated in the workplace directly or indirectly on the basis of their disabilities. So what this amendment has also done is to broaden the definition in line with the UN definition, which now includes people with long-term or recurring physical, mental, intellectual, sensory impairment, which in interaction with various barriers may substantially limit the prospects of those people to enter into a job or advancing in that person's employment if a person has got is a person with a disability. So it really, really is trying to assist employers to say, don't just ignore people, because disabilities are very broad. We probably have many people with disabilities in our workplaces, And the issue with the disability, John, is the attitudes of people that we find. It's not necessarily whether a person can or cannot do the job, but we find that the attitudes of individuals in the workplace are the ones that can be the most barrier. So what this is now saying is that employers need to create an environment that is inclusive, where there's awareness of what is disability and how can we support persons with disabilities, because they can equally be, productive in the workplace. So that's really that. So the Department of Employment and Labour is also on the back of this very, very adamant that 2% of employees must be a target for persons with disabilities. So they're not budging from the target of 2% with all the various sectors that they have engaged with. They're saying all companies must target 2% of their workforce being people with disabilities. Some organizations are saying, well, that's not going to be possible because our environment is not conducive to employ people with disabilities. So this definition is now spelling that away, to say not every disability must be a physical disability. It can be any other types of disabilities, including this long-term conditions like, depression. People who have a depression long-term, that can be seen as a long-term and substantially limiting condition, because that person may be substantially limited in functioning in their role if they are not reasonably accommodated. So there is a need, John, to create awareness, firstly, and put measures in place that will support persons with disabilities and those that work with persons with disabilities, so that there is a sense of inclusion for those people in the workplace, and that will then help. Thanks, John. I don't know if there's anything else here.
Yeah, Thames, maybe just a comment, because I've been getting a lot of queries from clients. First thing that you say, Thames, is colleagues, 2% people with disabilities, right? Tembi's shown you, and you're going to see just now, that the 2% is going to cut across all sectors. The ministerial targets are 2%. Not meeting that target is just as serious as not meeting your top management targets or senior management targets. So this is an opportunity for you, colleagues, to reopen the disclosure around people with disabilities, to create an environment that's conducive to that. But the point I want to make is sensory impairment is sight, hearing, smell, etc., etc. Now, please remember, disability's got three factors. It's firstly, it's long-term or recurring. Secondly, it's physical, mental, or now sensory, which is, I suppose, part of that. But colleagues, the fact Tembi and I are wearing glasses doesn't mean we're disabled. It's got to undermine or limit, look at the word, limit the prospects of entry into an advancement within the employment relationship. So Tembi and I, we're not limited in our advancement because we wear glasses. Global Business Solutions have not had to make reasonable accommodation for us yet, until we need big screens, maybe when we're 80, but right now it's not a limitation to us, colleagues. So therefore, the sensory impairment is not a disability. It's only when you've got to take reasonable steps to accommodate that person's entry into or progress at that point, Thames, it becomes a particular disability. But here's an opportunity to really take a fresh look at disclosure around this. Thanks, Thames.
Thank you, John. So on the same slide with the disability, I just wanted to maybe emphasize something on the definition of designated employers. So we have already answered some of your questions regarding employees, the designated employers definition. So we are also saying here, be careful if you make use of temporary employment services. As we know that in terms of the of Section 57, says that if you have an employee that is assigned to your company and they are with your company for a duration longer than 3 months, they are deemed to be your employee for the purposes of Chapter 3, which includes consultation, analysis, planning, and reporting, meaning that you've got to report on those employees. So you might say to the Department of Labor, no, we're employing under 50 employees, but then it is discovered that you are also making use of TES companies, and those employees are within your premises. Now you have to report on them, and that then pushes you over the threshold of 50 employees. That means you are then a designated employer. So everything that we are referring to here will then have an impact in your organization. And also just bearing in mind with the maybe on the next slide, John, the criteria that will be used by the department, by the minister for not issuing a certificate will also be as a result of a company being, referred to the CCMA, and where the employee has won that case. That will also mean the company does not receive a certificate of compliance. And that could also be an employee that was assigned to your organization by a TES. So it is very important that when we talk about elimination of unfair discrimination and harassment in the workplace, that the employer can be held vicariously liable. And there's also the joint and several liability that the employer may experience in cases of unfair discrimination as well. So I think that point here is very important, because one can say, well, we're not a designated employer, so we don't have to worry. But there are other ways that you can be found that you are a designated employer. Thanks, John.
James, if you don't mind, I want to just take this point and just emphasize it. Colleagues, there are two considerations, as Thembi said, when you use a temporary employment service. As Thembi says, after 3 months, those temporary workers get reported by you as the client. That could push you over 50, but it doesn't stop there. The second thing is, let's say that one of the temporary employment service assignees get harassed by your staff members or vice versa, and you don't deal with that properly and it ends up at the CCMA Labour Court. You could both be respondents and be found guilty, which means that both of you and the TES will not get a certificate of compliance. So I just want to emphasize that you need to have very strong, intimate relationships with your TESs, awareness training, policies, procedures around harassment. You need to stretch that across both yourself and your TES. And you need to ensure that yourself and the TES are aligned, that if there are any grievances or any disputes around this, that they've got to immediately be reported and brought to light so that you can take early action attempts. I mean, can you imagine, being a client using a TES, and before you know it, you being found guilty of something that you maybe weren't involved in, and then you lose your certificate of compliance. But it cuts both ways, and you need to work with TESs that are reputable, that are doing awareness training in this regard, and who've got policies and procedures around harassment. Thanks, Thames. Thames, I think you're on mute.
Thanks, John. Thought by now I would not be on mute. Thanks, John. So Section 15 is the new insertion on the employment equity legislation. So it's Section 15, capital A. That is the section that provides the minister with the powers to set new sectoral, or rather sectors. So there are currently 18 sectors from 11 to begin with. So they've had to increase the sectors and subsectors, and that is the consultation that is taking place with the Department of Employment and Labour. And the minister may, after consultation with various sectors, on the advice of the Commission, that for the purposes of ensuring there's an equitable representation of suitably qualified people from designated groups at occupational levels in that workforce. So what this is saying is that the minister now has the powers to set these sectoral targets at various occupational levels to ensure that people from the designated groups that are suitably qualified are equitably represented in the in that company's workforce. So, and I want to really emphasize this point of the suitably qualified people. Now, Section 20, subsection 3 of the Employment Equity Act, which is about the EE plans, it states that a person may be considered to be suitably qualified in the position if they have one or a combination of factors. And it lists those factors as qualification, experience, recognition of prior learning, and potential to acquire skills within reasonable time. So what Section 3 says is that when considering the EE plan and implementing your EE plan, you as an organization are required to put measures that will accommodate, reasonably accommodate people from the designated groups when they are underrepresented in the workforce by considering those individuals that are suitably qualified. And what suitably qualified means is that the person doesn't necessarily have to have everything that is required in that job, but they can have one or a combination of factors that are important, that are permanent, essential qualities, skills, knowledge, behavioral competencies of what is required for that job. So it's by no means say that the person mustn't meet the requirements of the job, but it says that if a person meets one or a combination of those factors, you may reasonably accommodate them as part of your affirmative action measures. So why I'm emphasizing this is that when considering your grounds, your justifiable grounds, you also have to have really analyze this process before you can say we are deviating from employing a person in line with our EE target because we did not have sufficient recruitment opportunities, or the persons that we identified did not meet the requirements of the job. Then you can definitely point back to this and say, did those people not have relevant qualification? No. Did they not have the relevant experience? No. Did they not meet the potential for acquiring this job? No. Then you are fine. But if you can't answer that, definitely, then it becomes a challenge for you as an organization. So that's why it is required that every person that is going to make a decision on hiring or promoting, they are also gone through this training. They understand that their decisions could have significant implications for the company, especially where there are no documents to prove and justify the deviation. So that's why we're saying put together your file, what we would call the litigation file. Make sure that all your justifiable grounds are legit. So that's really the point here, John. So the occupational levels, as we have said, that there will be subsectors, as we have indicated, and we've also gone through that the minister will then publish this. And that is really the process that we've already touched on. Thank you, John. We can move on. So the consultation process we've already touched on, but I would like to maybe just bring to your attention the current section as it stands. So, and this is what we have already indicated is being amended to really make it more what we have already discussed, which is on the right-hand side. So I'm not going to go into much detail on this, John. You can move on. All right. In this one, we are referring to the EE plan. So as I've indicated that the amendment on the Section 20 is also to include sectoral targets. So when setting the employment equity plans and your numerical goals and targets, it's no longer going to be at a discretion of the employer. It will be based on your sector. You have, however, the opportunity to set your yearly targets. And that's where the Department of Labor is saying that these are not quotas, because you still have the flexibility to set your yearly targets up to your 5-year target. And of course, it's important to also mention that if a company has already exceeded the sectoral target when doing the analysis and benchmarking, nothing stops that employer from improving further than the sectoral targets, because the ultimate benchmark is your economically active population demographics. So some sectors have pushed back to the Department of Labor and said, you're setting us lower targets than where we are currently. So are you saying that we must now reduce the gains that we have received in order to get to the sectoral targets? That is not necessarily the thinking behind. So the department is saying, no, if you have already achieved what we are suggesting, go ahead and improve towards the EAP. So some of the changes are on the reporting period. So the reporting dates, so the dates are still the same, but it's really just saying now we can start submitting the report as soon as the portal is open. And we know that they generally open the portal around the first week of September, and we start to report, and we can report up until the 15th of January. So if the 15th of January comes and you have not reported, the system will be shut, and you will immediately be a target for a certificate of non-compliance, because that's an automatic criteria for the department to use for not issuing certificate of compliance. So just to emphasize again, Section 42 is the assessment criteria that is used. It's for assessment compliance, to assess compliance for organizations. Section 42 has also included the sectoral targets as one of the criteria that is going to be used to assess whether or not the company has complied with the sector targets, and whether that employer has also complied with the sectoral target in terms of the Section 15 capital A as applicable to that employer. Section 53 is the biggest one, which is really the point that we've been mentioning all along, that this offers the minister the powers to issue a certificate of compliance. So Section 53 was not promulgated as long as the Employment Equity Act has been in place. Now they are amending this section, which is really all about state tenders, as John indicated, that even if you are not doing business with the state, you might as well be required by a company that you are supplying that is also looking at this as a criteria. So it's not necessarily going to be just the government tenders. It can be also other employers and companies that want the certificate as part of their procurement process. So as I've indicated, these are just some of the sections, and we've talked about this already. And then also just what I want to emphasize here, John, is it's Section D here, which talks to the findings on the CCMA or Court of Law in the previous 3 years. So you can see that that has been changed to 12 months. So what that means is if you have been referred to the CCMA and that employee has won a case in the last 12 months, the Employment Equity and CCMA systems are going to be integrated when it comes to these cases, and the system will trigger that your entity has been found guilty of discrimination by the CCMA. So you will automatically be denied the certificate of compliance because of this. And John had already mentioned the national minimum wage as well. So thanks, John.
Thembi, thank you. And I think for me, colleagues, what I get out of this, one of the key things is, as Thembi indicated, throughout your employment life cycle, when you recruit, when you promote, when you train, all those key touch points please keep, maybe it's a negative name, but keep a litigation file. In other words, if you were unable to appoint a designated person, you need to keep a file demonstrating that you considered suitably qualified people, not just qualifications, but you looked at relevant experience and the ability to acquire those skills in a certain period of time. Because you may very well be called upon, if you don't meet those annual targets and ultimately the 5th-year targets, you may very well be called upon to demonstrate why you didn't meet them and that you did take steps to look at suitably qualified people. Now, Thembi, the next few slides, I know you're going to pop through quite quickly, but colleagues, these slides are going to show you the trends on the CE report highlights and the importance of keeping this, let's call it justifiable reasons or litigation file. But Thames, over to you.
Thanks, John. So the slides really are indicating the 22nd Commission reports, which we get year on year. And as you can see that year on year, this report hasn't really changed that much. In fact, if you look at the report from 2001 up to this report, there's been really, really slow progress. So, I mean, I'm not going to go through the numbers. You can see that at top management level, it's still very much, you know, aligned towards white demographics, followed by Africans, and your gender representation as well. As you can see, it is pretty much still very male-dominated occupational level. But also what we're seeing here is the sectors that have performed the best. So best performers here is your public administration and defense, compulsory security, water supply and sewage. So those are your sectors that have performed well. Agriculture and forestry, accommodation, as we know that during COVID, most of these establishments had to close down. So we can see that, you know, they are the worst performers. But one can say, but well, this is not an overnight thing. It's always been like that. Yeah, that's true. But I think one has to also recognize that some of those that have performed even worse as a result of what we've seen in the past 2 years. Senior management, as you can see the numbers. I'm not really going to bore you with statistics. If you do want this report, we have it. We can share it with you. But it really just emphasizes the reason why there is a need for these sectoral targets, because most organizations have really not been able to put together meaningful employment equity targets. And simply because, you know, companies are looking at the current realities and say, we don't see any growth and we don't think that we're going to be able to employ people from designated groups. So therefore, our employment equity plan for the next 2 years is going to be X. So, and what would happen is that those employers will find opportunities, but because the plan is already indicated that they need fewer people from designated groups, so they would then appoint according to what they are receiving and not consider the fact that demographically they are still underrepresented. So that is what we are seeing with the statistics, that there hasn't been much progress, not because there haven't been any opportunities. In fact, you'll see some of the slides that are following in terms of the recruitment practices, that you will see that the recruitment practices year on year, they still favor people that are not from the designated groups. So that indicates to you that there are opportunities, but organizations haven't really utilized those. So John, this is really the breakdown that emphasizes the point that I indicated about CCMA aligning their system with the Department of Employment and Labor. So they are taking statistics of referrals together with awards of cases that have been won. So you can see that, you know, this breakdown is showing that there are quite a number of cases that have been referred. In fact, if you look at unfair discrimination cases on arbitrary ground, is 1,087 cases that have already been referred. Equal pay for work of equal value on arbitrary ground, sexual harassment at 80, unfair discrimination on race, pregnancy, age, disability, etc. So you can see the list of referrals. And no doubt that this list is going to increase, I'm sure, in the new year, especially at the back of the code on elimination of harassment and violence and harassment in the workplace. At this stage, we see that a lot of employees are not yet referring, but this new code, John, as you know, that it's quite interesting because it talks about rolling your eyes at me can be a form of harassment. Your view on that, John, because you must know, you must stop rolling your eyes at me when I'm talking to you, because now I can refer you for harassment. Your take on that, John?
Maybe while you were talking, I was thinking of the definition of harassment, rolling of eyes, obviously using vulgar language, Thames, and it amazes me how many of our clients have said, John, can't we just take that part of the definition out, because unfortunately vulgar language is, given the type of business we're in and the industry, it's used quite frequently. But colleagues, you've got to be extremely careful. You need to do training and awareness creation on harassment to not be vicariously liable. Because, yeah, looking seductively at your colleagues, rolling your eyes, using vulgar language, you know, very important. And of course, also the liabilities, colleagues, we've got to ensure our managers, our employees, our suppliers, they've got to understand that when it comes to unfair discrimination and harassment, you can be found wanting under labor law, civil law, and criminal law. So in other words, labor law covers employer, employee, and employee type jurisdictions, but suppliers, clients, harassment between suppliers and your employees or vice versa, PEPUDA, the Promotion of Equality and Prevention of Unfair Discrimination Act, can kick in. And of course, what's really interesting, colleagues, the PEPUDA Act actually says that if someone's found guilty of a civil offense, against someone for harassment, you'll see the second bullet point says it should be referred for criminal prosecution. So, you know, you might get a fine or whatever out of the civil process, but, you know, it doesn't end there. You can find yourself under criminal law as well. And you need to make your leaders, your managers aware of these dangers. Well, colleagues, Thembi spoke about the various employment practices. You know, we talk about the employment life cycle. And what is really amazing is if we look at the barriers to affirmative action measures, the highest percentage, 7,700 companies out of 27,000 said that their recruitment procedures are a barrier. Now, I don't know if it's a barrier because of alleged inability to find the right skills. I don't know if recruitment is a barrier, potentially for other reasons. But, you know, these are the types of statistics that you're going to have to keep in your litigation file. We see training and development, 25% of companies saying that's a challenge to affirmative action. And then one which I come across all the time, companies don't have proper career and succession plans. The 9-box matrix or 2-in-a-box, whatever it is, if ever there was a time to have proper career and succession planning, this is it. Not just for employment equity, but just for talent management. We are in incredibly difficult times. But I put this, I put this here because what's really amazing, colleagues, is corporate culture has only been cited by 8.2% of companies as being a barrier. Now, I said earlier, the secret of your future is hidden in your daily routine. Now, if recruitment, selection, training, promotion, retention is anything to go by, companies' daily routines are problematic when it comes to employment equity. And one of the reasons for that has to be because our organizations are not underpinned by leading and managing with emotional intelligence in this space, because there's a time for courageous conversations, but there's also a time for nurturing and connecting, because the very nature of what we're dealing with strikes at the heart of the employment relationship. And you've really got to make sure that you've empowered your line managers and your employees to be steeped in emotional intelligence. You cannot approach this just as a tick box exercise. You've got to approach this as an opportunity to drive organizational success. But colleagues, these are the examples of the habits of organizations. So recruitment over the last 12 months, 31% of all new appointments at top management were white males, 10% white women. So you still have 44% of all new appointments at top management being white individuals. You then go to promotion, 33% plus 15. It's 48% of promotions at this level still white, skills development, etc. Now, that is why we're saying you need to keep that justifiable reasons file handy, and you need to look at suitably qualified people, not just qualifications and experience. Because if you miss your targets, they're going to say to you, well, give us proof that you're training appropriately. And if you say, well, we're training 36 plus 5, 41% of all trainees at top management are white, I suspect you're not going to have a good argument in respect of those particular practices and justifiable reasons. Now, Thames, you comes from the horse's mouth. I mean, you're an employment equity commissioner, you have discussions. 94% of DG reviews result in non-compliance. Out of 860 employers, 94% were found non-compliant. Thames, take us through these big reasons for non-compliance.
Thanks, John. Yeah, so I mean, as you can see that the 94% of those, they have been found non-compliant. And some of those reasons are, what I have already indicated, the areas where they've observed that where the employers is required to assign one or more managers to take the responsibility of employment equity, that those employers did not have those appointments in place. Consultation not effective, people that have been nominated not equitably represented, as you can see that, companies did not have proof on the employment equity manager, did not have proof that this person has been properly assigned, or did not even have the resources and the budget to run with employment equity matters. And as we indicated, the section 16, the meetings not taking place, and also the just the whole representation of people that have been nominated not properly done. So, and we can see that this is one of the areas, in fact, all four of them, where the findings can lead to the fines. In terms of the section 16, where there were no registers, and the registers not even indicating what the appointed EE committee members, their representation in terms of their constituents is not indicated. So what we suggest to companies is that you must have the list of your employees that are sitting in your committee. You have to stipulate what constituencies that they are representing, because if you don't detail it in your minutes of the meeting as well as your agenda and your registers, then you are seen as non-compliant. Section 19, where also the findings where the companies, where they're required to collect information and conduct analysis of policies and procedures, these barriers were not done properly. As you can see that John had already referred to some of the barriers that the companies reported. Only a few companies have admitted to having barriers on recruitment, appointment, selection, succession planning. And yet when you look at the actual workforce profile, it still indicates that there are underrepresentations. So what this means, out of this finding, they realize that companies are not detailing their proper barriers in the Section 19 and the EA 12 documents that they have to submit. So that is really their finding. And then under Section 20, which is about the plan, their findings is that the organizations are not projecting reasonable progress towards transforming people in line with their targets. So the point I indicated earlier on about looking at reasonably qualified, reasonable accommodation of suitably qualified people, this is one of the findings that it's not clear how employers are really removing the barriers through reasonable accommodation of people. And also there's no reasonable progress towards transformation. That's what the plans are indicating. So that's really that, John, I think.
Maybe there is a question around the issue of if you are found wanting at the CCMA and you take it on review to the Labour Court, what happens with the certificate of compliance? And my view, Shivani, is if you take it on review, then it stays the implementation of the arbitration. So as long as the legal process is still in process, then then you should still be issued with your certificate. But those will be covered in the regulations going forward. Coordinate, Tembi, and I must say, I've also come across this, and I'm sure you have many times. Often labour inspectors find that they either make their own subjective decisions or they copy and paste their particular remedial actions, and they're not always fit for purpose. What's the best way for companies that feel that they are being unfairly, that the interpretation of law by inspectors is not quite what it should be, or they're imposing their subjective wills? Thames, what is the best response by companies where they're not correct findings, there's copy and pasting of inappropriate findings? How do companies respond to that?
I'm laughing here, John, because I'm dealing with the exact same challenge with one of my clients, where we've received 2 letters from the same inspector. One letter says that we found the company complying with Section 19 and 20 of the Act. And then the same letter gives us the recommendations to submit a plan and the analysis. So it becomes very tricky, because you're supposed to be compliant and then you're given recommendation to submit. And the second letter says we found you non-compliant. So now we confuse which one is which. So my advice always to companies is that don't just take that lying down. You've got to confirm. You've got to point out the areas of concern and put it in writing, send it to the inspector concerned, and note the areas that you are not sure about of what they are exactly saying to you, and then wait to hear from them. But I think it is important that, and you don't just sit back and say, well, we've got these 2 letters, so I'll take the one that I think it's correct, because you could then be sitting there and not clarifying the issues, and then only to find out that they refer you to Labour Court. And that's generally the process after they have submitted the letter to say complied by this date. And if you haven't complied by that date, even though it was an ambiguous response, if they believe that they found you guilty or non-compliant, they continue to refer you. So I think the onus and the obligation is still on the company to clear your name. So that would be my advice, John, on this.
Tembi, thank you. So let's get stuck into the ministerial targets, Thames. And again, we're not going to spend too much time on this, but what we do see here is we've got colleagues the various sectors and what we believe, Thembi, are the latest sort of status of the sectoral targets. Thames, maybe just take us in a bit more detail through this.
Thanks, John. I'm just going to talk in principle with one or two of these, which if companies or colleagues here on this call are keen on some of the sectors, we can share with you what we've got. So, for example, the administration and supportive activities sector engagement. So the process, how it went, is that the department called the sector and presented their proposed targets, which are mostly in line with the BE targets. That was the benchmark that they've used. For top management is 50% Black people, which is made up of African, colored, and Indian people, which is an aggregate from the national EAP, National Economically Active Population. So what they've done is they've taken the economically active population of Black people and did an aggregate for the percentage of only Black people. And based on that, they said what would then be a percentage of African people out of the 50% target. So the target of 50%, 87.1% should be African males and females. So that represents 43.5%, which is split into 50% of the gender. So we've got your male and female split 50%. Then your colored males and females, 5%, 1.5 being Indian. So that was the original proposal that they submitted to the sector. So they gave the sector the opportunity to go and engage with their companies and then come back with the responses to the Department of Employment and Labor. So the sectors, subsectors that were engaged or responded to the Department of Labor's proposal were SASSA as well as SANSIA. So this is more the securities industry, and then CAPES, which is representing the industry of employment, labor brokers and TESs. So CAPES' proposal was that we have looked at the workforce profile for top management across our industry, and they then proposed to the Department of Employment and Labor that they would propose 21.8% as opposed to 43%, or rather 39.8% as opposed to 43.5% based on attrition and also just the opportunities that they saw happening in this sector. And for colored, they said we are proposing 4.6%, and the department had proposed 5%. They then proposed 1.4% for Indian people, where the department had proposed 1.5%. On the other hand, the other sectors, they proposed that they would propose 43, my eyesight, for that was SANSIA, and 5% and 1.5%. So they didn't disagree with the department, basically. So if you look at their target and proposal, except for African female, that's where they differed slightly in line with what the CAPES as well had proposed. So what then has happened is that CAPES and SANSIA and the different sectors that we're engaged submitted this information to the department. They reviewed it and they called another meeting to say, we agree with your proposal. And in fact, what we're now saying is we will take the proposal in line with what CAPES had indicated. So really, the final proposal by the department is on white here. It's 46%, where CAPES was 45.7% in total. So you can see that they have been taking into consideration some of their submissions, but in some instances they are not budging because they're saying companies are not really being realistic in these targets. At senior management, you can see the target is 60%, and the proposal from CAPES was 54.5%, and SASSA and SANSIA was 60%. And overall, the department has proposed 56%. Again, not too far from what CAPES had proposed. So you can see that they also said it's fine. We are not going to come back to our 60%, but we will agree on what you're proposing. Thanks, John.
My apologies. Thembi, yeah, so colleagues, these are the targets, Thames, and these will be the outcome of the 5th year. So my understanding is when you do your employment equity plan, it would be these targets that you put into the 5th year. And the 4 intervening years, you would set your own targets, but by the 5th year at top management, you're going to have to get a 46%, at senior management, 56%, etc., etc. And then there's the 2% colleagues that Thembi was talking about in respect of people with disabilities. So they haven't budged across that. And of course, as we said earlier, you need to work at that. So here's the current agriculture, forestry and fishing sector, arts and entertainment, recreation, including rugby, the rugby union, and wholesale and retail, trade of motorcycles, and public administration. And Thembi, what's interesting here is we see top management, they've gone straight to the national demographic, right? 91.2% is the black target. And that's really what you were referring to, Thames, that where organizations are already, if you take a look at this at the bottom, public administration, government, basically, they're already at 80.8% black representation. So they'll be heading for a 91.2% representation at the top management level. We then have mining and quarrying, accommodation and food services. And here you can see they are still busy consulting. So that hasn't been tied down yet. And then, of course, a massive sector is storage and transport sector, and also still very much in the process of consultation. But the government, or rather the proposed targets by Department of Employment and Labour at top management, in line with the BEE management control numbers, 50% at top management black representation, 60% at senior, 75 at middle, and then at junior management level, 88%. But as you can see, colleagues, 2% people with disabilities. So obviously you should have these slides, or you should be getting them shortly if you don't have them. And you can take a look at this and start moving towards your sector targets. If you have any other requests, colleagues, maybe beyond this, please get hold of Thembi or I, and we'll keep you updated in terms of the developments in that regard. Colleagues, as part of an added value to you today for joining us, is Thembi and I work with a planning tool, and you'll be getting an Excel spreadsheet. So it's not incredibly fancy. It doesn't have all the bells and whistles, but the tool that we've sent you really assists you with the target setting process. So what it does is it's an Excel spreadsheet. You right at the top here, you will insert your current workforce. So if we look at the bottom, the top management tab, so you would insert your actual number of top managers: African, colored, Indian, white, male, African, colored, Indian, white, female, foreign nationals. Then the national EAP, the latest EAP is in there. Then you insert your sectoral targets based on the 5th year. Colleagues, this will then give you a result, and it will effectively tell you where you are over or underrepresented. And then you would have your envisaged changes for 2023, 24. So if you envisage changes, people retiring, people potentially being employed, for each year you would insert your envisaged changes, and then it will give you a deviation, either a above or below deviation. So fiddle with the sheet, start taking a look at the gap analysis, and then effectively you can start taking a look at what is the extent of what needs to be done in terms of meeting these targets. And the great thing, it doesn't just give you percentages, it gives you the actual number of heads, the actual number of staff that need to be recruited, promoted, etc. Thembi, I don't know if you have any other comments on this tool. I mean, you developed it, and we've been using it quite successfully.
Thanks, John. All I can say, it's a very lovely tool to have, given my digital capacity. So I needed something that that makes sense to me. But I must say it's quite nice to work with it, because you can actually plot your entire 5-year plan and targets, which you can just literally transfer to your EA 13 document, where you have your 5-year plan. So it's quite a nifty spreadsheet to have, John. So yes, that's all I can add there. And then at the bottom, you can also detail your comments, your findings per occupational level. If you've had opportunities, you can detail, you know, how many opportunities you anticipate, be it on retirements, and so you can actually plan that year on year. So yeah, that's all I can say, John. It's quite a nice planning tool.
So Thembi, my daughter calls me a digital refugee. She says she's a digital citizen. I don't know if that's a form of harassment, being called a digital refugee.
Yep, I would agree.
Good thing, Thames. Maybe Papuda will help me there. Civil action against my daughter. But colleagues, so we look forward to that. Thembi and I, maybe we can run a free 1-hour session at some point. If you are battling with that schedule, maybe Thames and I can take you through how to use it, but see if you just fiddle with it. If you're refugees like us, digital refugees, well, maybe we need to put a 1 hour aside just to take you through it. Failing to meet targets, colleagues, Thembi and I have done a lot of work in terms of this. This is the litigation file, or let's call it the justifiable reasonable grounds file. So you need to get your line managers and human resources colleagues orientated, so that whenever they've got recruitment, promotion, training, whatever opportunities they have to either move towards their goals or to detract from their goals, please keep reasons, evidence, proof that you looked at suitably qualified people and that you took reasonable steps. If you keep that file, then if you don't meet your targets, at least then when the certificate of compliance gets questioned, you can give evidence of that. In the absence of that, I suspect you're going to be out in the cold. Anyway, colleagues, this is just an example of the EEA 15, where you would make a submission to request a compliance certificate. You can see you'll have to make certain declarations in terms of paying the minimum wages, not being found guilty, but of course, there will be the interface behind the scenes. Maybe just a final comment before I end from my side and ask Thembi to just wrap up. Colleagues, the certificate of compliance will definitely be part of the Preferential Procurement Policy Framework Act. Already, the PPPFA has been amended to state that one of the qualifying criteria to qualify for government work will be to attach your certificate of compliance. So very, very important for us. It makes business sense, it makes performance sense, and it makes inclusion, equity, diversity. It's been proven, colleagues, that organizations that embrace this are much more productive, much more sustainable than other organizations. We need to have growth mindsets. We need to look for opportunities. And I know it's incredibly difficult in these times. We've got many pressures from all sides. But you know what? There's an opportunity here to move forward with distinction. And I think for me, the lasting comment would be Simon Sinek. He always talks about a leader versus a manager. And he says a manager is someone who takes charge of the people in their control. Employment equity requires us to have managers who take charge. In other words, managers who understand the plan, who understand the business drivers, and who make the right decisions. But colleagues, it doesn't end there. We also need leaders. And we need leaders who take care of the people in their charge. And to take care of people at this point means to empathize, to listen, to understand. We may not always be able to meet everyone's needs, but we can let them know that we care and that we take an interest in them as individuals. So if you bring leadership and management together, colleagues, then of course you can see this as an opportunity and not something to be feared. So in light of that, Thembi, thank you so much as this joint CEO, my colleague, and also a commissioner, to share with us insights so we can be proactive. Colleagues, to all of you who joined us, thank you so much for joining us. Please follow us on LinkedIn, our Global Business Solutions page. We're doing a lot of work there, and all the best. Thank you very much. Over to you, Thames.
Thank you very much, John. And just to thank everyone who's here. And yeah, we appreciate your support always. And I think, John, you've said a lot, and it's always great to facilitate with you. I learn a lot and I become clever as you. Thank you. And thanks, everyone. All the best.
Thanks, Thembi.